curious of your input on this.
Court, all rise. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated.
Good morning and welcome to the Appeals Court, and more specifically, the newly christened Christopher Armstrong Courtroom. I'm Judge Milkey. To my right is Judge Walsh. To my left is Judge Hershfang. And together we are your panel on the 5 cases we're hearing today. I should tell everyone, I suspect you know already, but I will tell you we are being live streamed today as part of a pilot program. So it's important that all of us be on our best behavior on such things as making sure we obey the impoundment rules to the extent victims' names are impounded and such. I want to assure everyone that we have read the briefs and the record, so we're familiar with both the facts and the arguments. I say this because 15 minutes per side is generally not a lot of time, and it's important for you to, if you will, cut to the chase to the extent possible. That said, if you feel like you've made your points, there's no shame in sitting down. As one of our former colleagues used to say, if you hit a home run, there's no reason to run the bases twice. And with that, I will call the first case of the day. It is Paul versus HALVORSON, MD, 2022 P. 108. Ms. Paul.
Good morning, Your Honors. I'd like to start out with talking about expert testimony. There are a number of cases that have been decided in the past where expert testimony was not required due to verbal admissions by defendants. In this case, there is written admission in the operation report of defendants' lack of due medical care to appellant.
Are you referring specifically to the statement that the dermatome was not corrected?
Yes, that's part of it. So I would like to point out that some of these earlier cases would say the tooth fell down the throat. In that case, you could have said the second bicuspid fell past the epiglottis. And so you have a scientific way to say it, and you have an everyday way of saying it. In my case, they could have said the tool that slices the skin was not set to the correct depth. Hence, we had to take a second slice of skin and graft the first error slice.
But don't we need an expert to be able to understand what that statement means, that the dermatome was not corrected?
Well, I think if you said it in layman's terms, it would be a tool that needed to be calibrated, and it was not.
I think, just to follow up on Justice Milkey's question,
Yes.
We're obviously lawyers up here, and so part of what we're trying to assess and the tribunal assesses is when you see a statement like that, I don't disagree that it probably could be interpreted the way you were suggesting, but what do we have, what additional information would we need to know what the effect of that is? For example, I could tell you, well, I don't know, I chopped my carrots with the paring knife instead of the chopping knife, and if you know about cooking, you'd think, well, okay, it was probably a little harder to cut your carrots, but, they both work. We're not in a position as lawyers to know what it means that the tool wasn't adjusted. Does that make sense?
I think the wording itself is obvious in this case, that they said they had not set it to the correct depth. Whether or not you want a dermatome explained by an expert, or, the medical record itself could have been written in layman's terms that a tool was not calibrated properly, set to the correct depth, whatever. The words are, had not. And then they took they had additional surgery. I think that is completely obvious in the operation report. I actually didn't know that until I got my actual medical records. I was told, the appellant was told that her skin was very thin.
I'm sorry, I missed that list.
Appellant was told that her skin was very thin.
And is that in the record?
That is in the briefs, and also in the offer of proof.
You make many arguments along the way. Can you tell me what you think your strongest argument is, whether it's a summary judgment or the medical tribunal?
The most important part to me is the tribunal, because what it did is it forced me to lose two of the main defendants when it comes to medical malpractice itself. There was no ruling directly on my affidavit of indigency. I would have paid the money had I been able to. Had I not paid my mortgage, appellant not paid her mortgage, used up all...
Feel free to use first person.
Okay, all of her credit card. I asked for an extra $1,000 from my ex-husband at the time. He wouldn't give it to me. I could not make $6,000. And there's only, I'm sorry to say this, but the lower court justice made cryptic note on the first page. And it doesn't mention anything about my affidavit of indigency, and it does not mention anything about the substance and the extent of my offer of proof. There was many pictures, medical records submitted, which is to the benefit of the defendants. And that's part of why we have to do these tribunals, that's my understanding. And clearly, my offer of proof had huge amounts of substance, cases, medical records, pictures, and I believe my offer of proof was enough to get past the tribunal.
Well,
Excuse me.
it would seem to turn on the expert issue, because there is a
It's-
fairly strong presumption that an expert is needed in such cases. So the question, as you properly focused on, is whether statements such as the dermatome was not corrected is enough to prove the kind of exceptional circumstances where courts have said, in this case, you don't need an expert.
I think the wording is pretty obvious that they are saying, in essence, they made a mistake and they had to do further surgery. If they want to put it in technical terms, scientific terms, as I said about the tooth falling down the throat, they could have said, we didn't set the tool properly to the proper depth and took it too far into the dermis. But certainly not full thickness. I'm being sarcastic here, yes. And I think that that is also, I think that is important. But also I'd like to bring up the falsification of the medical records. Okay, so we have a medical record on 8/28/2014, a discharge summary that says patient doing well, ambulating safely, voiding without issue. As such, she is sent home as an outpatient. The next medical record from the hospital is on 9/3, 8 days later, after I was home with all these burns. And the next medical record is only a summary of an ambulatory care appointment I had with one of the residents, Kristen Ojomo. And during that one, it says, and this is the only one in between 8/28 and 9/11. The only medical record is on 9/3, as far as I know. And she states on multiple things, no swelling, but I have pictures. She states consent was obtained, and the consent I signed, it is not in the medical record. I signed a consent that day, and I wrote in that Dr. HALVORSON, the attending, should perform the surgery. It doesn't exist in the record. So I can't proffer that right now because it doesn't exist. And so you have 8/28/2014, patient doing well. On 9/3, you have patient, apparently, she's fine, no swelling, et cetera. But then after 9/11, after my first surgery, a couple of days later, they started putting a note into the record. Patient initially declined, all caps. Much needed excision or debridement grafting. Reluctantly last week agreed. And that is false. You have 8/28/2014, patient doing well. You have 9/3/2014, okay, we will give you surgery. Then you have sometime after 9/11, a note that began to be put into the record. It wasn't completed until about 3 or 4 days afterwards, if you look at the notes in succession. And I didn't see that note until I got my discharge summary around September 19th or 20th is when I looked at it. And I realized that there's some sort of a cover-up. In other words, you can't say, okay, she's doing well, and then we're giving her surgery, and then a few days after, or for me, the discharge was after 9/19, and all of a sudden say, oh, by the way, she declined. I mean, if you take those three statements, there's something wrong here. There's a lie somewhere. Either I wasn't doing well, I guess I wasn't doing well, because I declined much-needed excision and grafting, and where's the declination? There's no declination. I wasn't offered it. And I think this is obvious. I think anyone would see that. In other words, there are no medical records in between these occurrences.
Can we go back just for a minute to the question of the bond
course.
amount? So as I look at the statute, General Laws, Chapter 231, Section 60B.
Yes.
As I read that, it looks to me as if the judge doesn't need to make a finding of, well, needs to make a finding of indigence if the judge intends to reduce the bond.
That's not, I don't read it that way, Your Honor.
How do you read it?
I
and why?
read it that the first thing the lower court justice should be doing is ruling on the affidavit of indigency, and that the reason to reduce the bond, keep the bond as is, or increase the bond has to do with the substance and the extent of the offer of proof itself.
So in a case, for example, I'm not talking about your case now, just a hypothetical where someone was unquestionably indigent, received public assistance, had no other income, but also had presented a case, let's just say, that didn't have the strong facts that you have. In your view is that the judge is required to rule that the person is indigent and then go on to determine whether or not the case merits, whether or not there's a, whatever the standard is for going forward?
Yes.
Okay.
I believe I have a case in there that
Okay.
discusses
Do you remember
that.
which one?
Excuse me?
Do you remember which one?
No, I apologize. I do not remember which one, but within that, I believe there is a case that discusses that. I didn't bring my file with me, and I had a lodging issue Saturday night, so
Okay, thank
I'm
you.
pretty tired. You're welcome. I would also like to bring up Judge Wilkins' lower court decision on this matter, Justice Hershfang. He wrote in there, and this is in the brief, about perhaps dispositive flaw. So he clearly was not sure if I needed an expert. So I think this is an indication here that it was questionable, even in that judge's mind, whether or not an expert was required. I do believe it's up to the jury to decide whether or not this is a problem. Whether or not there are lies in the record, it's up to them. Whether or not they understand the dermatome was not set, as they say, they had not set the dermatome to the correct depth. I believe it's up to the jury to decide whether or not that is an admission of negligence.
You have 2 minutes left, if you would like to use it.
I do believe that the burns, especially for the fact that I have so many pictures, which are dated, in the metadata of the pictures. I am a picture taker. I believe the pictures, when shown to a jury, that they would believe that I should have been hospitalized. On top of the fact that we have the decline, much needed excision part of it from the hospital records. I think that in conjunction with the pictures that I have, that a jury would agree that I should have been I should have remained hospitalized. And there was a nurse, when they extubated me, there was a nurse that said, "Don't worry, you'll be here for a couple of days, then they'll do your grafting operation, you'll be fine." Because I wasn't fine. I was quite disturbed and hysterical, to tell you the truth. So, I guess that's it.
Thank you, Ms. Paul.
You're welcome, thank you.
For the record, if you're looking for a career change, you might consider law school.
I need a bachelor's first.
Thank you. We'll hear from Mr. Connors.
Thank you. May it please the court, Matthew Connors on behalf of the appellees Indranil Sinha and Eric HALVORSON, MD. I would just like to start with the overall statement under which all tribunals are measured, which is the directed verdict standard. And the offer of proof, even if we accept the allegations as true as to both of the defendants named in the trial court, was insufficient as a matter of law to raise a legitimate question of liability. If that evidence had been presented to a jury, I would respectfully submit that both defendants would have been entitled to a directed verdict. I'd like to start with Dr. Sinha first. Dr. Sinha's only role in this case, and as identified in the record, is that he was the clinical contact at the Brigham and Women's Hospital. There is no explanation from any qualified provider or any qualified professional as to what a clinician contact is. There's no explanation in the offer of proof as to what standard of care would apply to this clinician contact. It's not clear if this is primarily an administrative role, whether it was a medical role. It's not explained in any way in the offer of proof. Dr. Sinha was not involved in any way in the subject surgical procedure on September 11, 2014. He had absolutely nothing to do with the surgery. He wasn't in the room. He had nothing to do with the dermatome. It was entirely unclear with respect to Dr. Sinha why he was even named as a defendant, other than the fact that there was a personal belief on behalf of the appellant that he had a significant and large role in managing her care. That is not borne out by the records or the evidence that was before the tribunal. There was no evidence to support the claim that Dr. Sinha was somehow responsible for all of the care that was provided to the appellant, nor is there any evidence in the offer of proof that anything Dr. Sinha did in any way caused an injury to the appellant. So with respect to Dr. Sinha, I think the tribunal's finding was absolutely correct. There was no evidence to support a claim against him. With respect to Dr. Halvorson, the offer of proof did not contain any expert support for the claims against him. The offer of proof did not state what the standard of care was for an average qualified surgeon on September 11, 2014, when utilizing a dermatome for the performance of a tangential skin excision and for autografting. There was no expert testimony that Dr. Halvorson breached the applicable standard of care.
Could we go right to the statement?
Yes.
About the dermatome not corrected? Why couldn't a jury, had this gone to a jury, have concluded based on that something significant wrong was done here?
Certainly that statement indicates that a mistake was made, an error. We can take that as an error or a mistake. And for the purposes of our today, we will accept for argument that it was an error or a mistake. Under our case law, an error or a mistake does not necessarily equate to malpractice. You would need a physician expert to say that failure to correct the dermatome, and we're talking about 19 1/1000ths of an inch, that not correcting it, that was a departure from the standard of care. That's not an opinion that can be rendered by a lay person. Secondly, when you look at the operative report, which starts on page 64 in volume 2 of the appendix, on page 65, the operative report clearly shows that it was not just Dr. Halvorson in this operating room. Jeffrey Sisk, MD, and Kevin Huang, Huang, were both in the room. There's no delineation of responsibility set forth in the offer of proof. Which of these three physicians was utilizing the dermatome? Which of these three physicians was responsible for setting the depths on the dermatome? Which of these three physicians was responsible for checking to see if the proper depths were set? And who in the room actually utilized the dermatome to remove the skin? Those questions are all unanswered by the offer.
How is a plaintiff supposed to answer those where the discovery has not yet occurred?
The way to answer that, Your Honor, would be to have an expert to explain and to look at that operative report and say either, even if we disagree with it in the offer of proof, to say, in my opinion, who has been named, the attending physician, Dr. Halvorson, is responsible for setting the dermatome or checking the dermatome. Or even if he permits, which he's allowed to do under our case law, a resident or a fellow to do it, he still has an independent duty to check the dermatome. So that opinion's missing. There is no opinion that simply because he's the attending, He is responsible for errors made by other physicians in the room. In fact, our case law says exactly that even if errors are made by other providers in the operating room, that does not necessarily mean that Dr. Halvorson himself was negligent. He is allowed, under our cases and under our standard of care, to permit a fellow or a resident, as long as they are qualified, to do everything that was done with the dermatome. So without an expert opinion to say somehow he is responsible for this under the standard of care, the offer of proof is deficient as a matter of law. With respect to the cases that were raised about it is crystal clear when we have negligence in a case such as a dental case, and oddly there were a number of dental cases where that seemed to happen. And the reason those cases were allowed to go forward without expert support was because the dentist was in sole control of the instrument or the tooth or whatever it was. And then later, there was either an instrument or a tooth found on an x-ray in the patient's body. So there's absolutely no question that there was an error made and no question that the dentist was in sole and exclusive control of the instrumentality that caused that problem. That's not this case. In fact, and I don't mean to over-speculate here, but there are certainly a number of cases in teaching hospitals where the representatives of these companies that utilize these devices are actually in the room, and they set them up and they hand them to the providers. Some devices are set by nurses.
Is this in the record?
It's not. I'm just saying as an example for argument that there are so many questions. But to get back to basics, without an expert to say that irrespective of who set this or who used it, Dr. Halvorson's responsible, the offer of proof is sufficient, and he would be entitled to a directed verdict if that testimony was missing at trial. We have, in that regard, as the court is well aware, in the medical malpractice area, we do not have a captain of the ship doctrine here in this Commonwealth. As I mentioned earlier, Dr. Halvorson is not responsible for everything that happens in that room. And so if an error is made, and even if he comes to the patient and says an error is made, he's not automatically liable for that error. And finally, I do want to just point out for the consideration of the court that Dr. Halvorson's deposition was conducted in the case, and he was not asked a single question about this surgery. He was not asked about the dermatome, he was not asked about what happened, he was not asked about who made the error. Not one question was posed to him about this surgery. So those questions, although that deposition occurred after the tribunal finding, certainly could have been answered if Ms. Paul's attorney wanted them answered, and we could have had these answers, but they were not asked, and therefore there is no evidence to support the claims against Dr. Halvorson. Finally, there are a number of claims that the court has seen in the brief about negligent discharge, violations of various statutes, informed consent, use of improper medications and other things. All of those would require expert support. It is not enough for a counsel or a self-represented party to assume or to state that various statutes were violated, a discharge was premature, or that any medical treatment was negligent without expert support.
Could you address the issue of the records?
Which one, Your Honor?
The question of whether the absence of sort of a transitional record in terms of the appellant referred to it as falsification of the records, but focusing on just the specific facts, patient's doing well, and then suddenly, oh, patient didn't consent, and there's arguably something missing in the transition.
So from our vantage point, Your Honor, there's nothing missing from this record. The records have been produced multiple times. I think the hospital had produced 3 or 4 sets. I think, with all due respect, what is happening is there's a misunderstanding of the records. There's no inconsistency in the records. It is certainly permissible and logical that a patient might say, you know, I'm doing okay, and a surgeon might say, it is appropriate at this time to defer your surgery. We can wait. We can do these grafts later as long as things are looking good. and then the patient changes his or her mind, or if a patient refuses. These are all credibility issues that are far beyond the scope of the tribunal. But what the defendants would say is, she initially refused. It's in the record from multiple providers, not just Dr. Halvorson, multiple providers, and a nurse, that she refused the skin graft the first time around. That's an issue of credibility beyond the scope of the tribunal that the tribunal wouldn't decide. And then there's records that she wanted the surgery. She came back and ultimately changed her mind and wanted the surgery. We don't see any inconsistency in that. There's certainly no evidence, no actual evidence before this court or the lower court that anything was falsified or deleted or destroyed. There was certainly no vigorous search by Ms. Paul's counsel below for anything in that regard. If they asked us for it or subpoenaed it, we would have done it. We produced the records. There was no real discovery conducted on these issues about falsified records or deleted records. It's a red herring.
You have 3.5 minutes left if you would like to use it.
I have nothing else. I just want to thank the court for its time this morning, and for the reasons stated in our brief, we would respectfully request that this court uphold all of the lower court's findings that are before the court today.
Thank you both very much. The case is submitted. Our second case of the day is 2022 P290, Mount Auburn Hospital versus Progressive Direct Insurance Company. Counsel.
Good morning. Brittany Pierce on behalf of Mount Auburn Hospital. In looking at this case, I think it's important to take a look at what Progressive did both before Mount Auburn Hospital filed suit, then what it did after Mount Auburn Hospital filed suit, and then to look at those together.
Can we, I agree with that, but can we start with the second part of that?
Sure, after?
Yeah, because putting the timing issue aside, it seems that both the policy holder and the injured party made it abundantly clear that they wanted nothing to do with any claim and that they would not cooperate. So putting the timing issue aside for the moment, why wasn't that enough to establish that there was no cooperation and potentially, of course, no coverage independent of that, and the case is over?
Well, I think the timing plays into why that does not show non-cooperation, because the auto policy says that an examination under oath must be requested within a reasonable time. And here, the request that was made came not only 2 months after Mount Auburn Hospital filed suit, but it came after Progressive had done nothing for 7 months to try to contact the patient in this case. And I know that Progressive does make a big issue out of its attempts to contact the policyholder, Mr. Ocampo, but that doesn't have any bearing on what happens here. Because the patient, Ms. Zapata, her cooperation is what's at issue here. She was the patient of Mount Auburn Hospital.
Why don't you need both?
Bills. If Mr. Ocampo had a claim and they needed information from him, I think that is relevant.
But isn't the key issue whether or not she was a household member of Mr. Ocampo's, which is a question he could answer just as well as she could?
I think that they are trying to claim that that was an issue, but a major problem with that is that they never even attempted to contact Ms. Zapata at Mr. Ocampo's address of 1100 Governor's Drive. in Winthrop. They only attempted to contact her by sending letters on 4 different dates, all within about a month to a month and a half of a period, to an address of 12 Cushman with a K Street.
No, we have
And-
read the briefs.
And that is not even an address, that's not her correct address, and it's not an address that exists. If they really needed to know whether she was a household member of Mr. Ocampo, it would make sense to try to reach out to her, at least at that address. But in addition to that, they had later received information as of May 29th of 2018 from both Mount Auburn Hospital and the emergency room physicians that listed an additional address for her, which was 12 Cushman with a C Avenue, and they didn't make any attempt to contact her at that address. The emergency room physician's bill also had a phone number listed on it, and they did not make any attempt to contact her at that phone number to try to see if she was a household member of Mr. Ocampo, if that is in fact what was a major issue here.
So just if I can put this in terms I can understand, it is clear that they contacted her by the time a lawyer purporting to represent her and the policyholder contacted Progressive and made it again clear that they wanted nothing to do with this claim. So your argument is that's irrelevant because at that point Progressive had already violated, if you will, the terms of the policy, and therefore they're liable to the healthcare provider?
Correct. They had already violated the policy by not requesting the examination under oath within a reasonable time when you look at everything that they did in attempting to contact the patient here.
Okay, but say they don't need the examination under oath because Ocampo says, well, she was indeed a household member. Why isn't the case over on that grounds?
I don't believe that that happened here. I don't know that they ever received any confirmation that she was a household member. And in that case,
Because Ocampo, who was called 10 or so times, refused from all appearances to cooperate.
And that is an issue as to him, but the focus here needs to be on Zapata and the Progressive's attempts to contact Zapata. And what they did with regards to her is extremely minimal and doesn't amount to the diligence and good faith that was required. So then when you look at the 4 mailings that they sent, all within 8 weeks of the accident, and then they did nothing for 7 months until after Mount Auburn Hospital filed suit, and then suddenly they need an examination under oath. They could have tried to take the examination under oath at the outset of the claim when they were initially trying to contact her. They could have tried to contact her at the address that they received on those 2 additional bills. They could have tried to reach out to her by telephone. They could have tried to contact her at Mr. Ocampo's address, but they didn't do anything. They took literally no action beyond just mailing out those letters within 8 weeks of the accident until after Mount Auburn Hospital filed suit, because then at that point, they suddenly realized, oh, we need to figure out what to do with this claim, and they then requested the examination under oath at that point, and from all appearances, to manufacture a defense that they wouldn't have had prior to that because they made such minimal efforts to try to contact Zapata. And in addition to that, I think that the failure to pay Mount Auburn's bills was another breach of the auto contract, because in this case, it seems that they had the information that they needed. The auto policy says that bills are to be paid within a reasonable time, usually 30 days. And here I think that it's clear that they had the medical records, they knew the treatment that was rendered, and they had what they needed to pay, or they made very minimal efforts to get the information that they're now claiming they needed. When they refused to pay, they...
Why do you think they were spending so much effort trying to reach Ocampo?
As the policyholder, I assume that was an individual that they would want to reach out to obtain information. And I don't know that their efforts were that excessive in regards to Mr. Ocampo either. I do agree that they made more efforts to contact him than they did Ms. Zapata. But again, their efforts to contact him don't apply to Ms. Zapata and their efforts to contact her, and whether an examination under oath request of her, given their attempts to contact her, was reasonable. It might be a different story whether their examination under oath request of Mr. Ocampo is reasonable after.
Why
the
does it
attempts.
have to come down to an examination under oath when, again, they have tried to reach him, I think at least twice by email, 3 or 4 times in writing, and 8 or 10 phone calls, the last of which he hung up when he heard it was progressive? Why isn't that enough in order to try to seek the cooperation of the policyholder?
Well, I mean, Progressive didn't deny the claim at that point. I don't know its reasoning as to why it didn't do that, but it, may not have thought that that was sufficient to satisfy it in order to deny for non-cooperation.
Could you clarify something that I find confusing in the record? You say "the claim." I'm trying to figure out how the claim materialized. There is a suggestion in the record that it was the Arlington Fire Department that initiated the claim. And even though the letter from the lawyer it says, we are withdrawing the claim, it's not clear that either the policyholder or Zapata ever themselves filed a claim. Am I right in reading this, that it's the Arlington Fire Department that initiated the claim?
I don't recall off the top of my head exactly how the claim was initiated in this. However, I do know that they were notified, Progressive was notified of the accident as of at least March 27th of 2018.
By the other driver?
That may be correct, yes. And then at least as of May 18th of 2018, they knew that she was injured, and they received Mount Auburn's bills and medical records as of May 29th, 2018. And the provider does step into the shoes of a claimant, and so by receiving the bills and everything, that was sort of furthering the claim for PIP benefits, given the assignment of benefits, with the provider now saying, we're owed these bills for the treatment that we rendered for this individual.
I know, but
who was in
when
an
you referred
accident.
to the insurer at that point hadn't denied the claim, in a situation where the policyholder, unless I'm missing something, has never filed anything, has been able to escape being contacted, from all appearances wants nothing to do with this, why wasn't it reasonable at that point to the insurer to say, well, we're not going to do anything, there's nothing before us?
Because again, it's Zapata whose claim is at issue here. She was the driver of the vehicle. She was the one who was injured and
But
who
she didn't
Mount
file
Auburn
anything.
Hospital treated. But Progressive did, they were notified that there was an accident, they knew that she was injured, and then they received the bills and medical records. So there is a claim that is for Zapata at that point for her PIP benefits. And they had that information and made minimal efforts to contact Zapata, which I think is a really important issue when looking at the examination under oath. They couldn't have denied her claim prior to that because they made such minimal effort to contact her. They sent letters to an incorrect, non-existent address and did nothing else despite having information that they could use to contact her. They could have sent it to the other address. They could have sent mail certified. They could have sent somebody out to her house or to the 12 Cushman Street address they had mailed documents to see if she actually lived there, which would have shown them that that wasn't even an address that existed. There were many ways they could have attempted to contact her, but they just sent those 4 mailings out between April 4th, 2018 and May 17th, 2018, and then did nothing. They didn't deny the claim. They didn't, make any efforts to contact her. They did literally nothing. And then it was only after Mount Auburn Hospital filed its suit, because the bills had remained unpaid for 5 months, that Progressive then decided, oh, let's request an examination under oath. And then at that point, that's the very first time that they sent mail to her certified, and also the very first time they attempted to contact her at the 12 Cushman Avenue address that they had received both from Mount Auburn Hospital and the emergency room physicians back on May 29th, 2018. So they sat on that information for 7 months, and then it was only once they were faced with suit that they chose to then make these efforts to attempt to contact her. And I think that just helps to further show how their efforts prior to that were insufficient. They could have sent something to her certified at any point, or requested an examination under oath at any point, or sent a mailing to the 12 Cushman Avenue address at any point.
I'm sorry, but we're running out of time, and I just want to make sure I understand sort of the temporal aspect of your argument in context. Let's just assume for the moment that Progressive had accelerated all of those actions and had gotten at the 3-month mark, the denial from counsel. I represent both of these people, neither one of them is ever showing up. Would you still be here, and why?
I think if we're saying that at that earlier stage they had sent certified mail to the correct address and then they refused to appear for the examination under oath, I think that's a different story. But what you're looking at here—
But that's the story I'm interested in. I'm interested in how your reasoning would apply to that story.
But I think that under those circumstances, that is more of an effort on Progressive's part to make contact with the patient, and at that point, if the patient refused to show up, then there's different circumstances that you have to look at.
So your argument hinges entirely on the passage of time between when this woman was brought to the ER and the time that the lawyer said they're never showing up for their examination.
Because an examination under oath must be requested within a reasonable time pursuant to the policy, I think, yes, that's extremely important here to look at what they did and then how much time went by where they did absolutely nothing. And then that helps to demonstrate that this, in fact, was not requested within a reasonable time, and therefore she had no duty to cooperate at that point.
Counsel, I'm afraid your time is up. Thank you very much.
Yeah.
We will hear from Progressive.
Good morning, Your Honor. Bruce Medoff with my co-counsel Joni Connors on behalf of the appellee. A couple of things that I noticed over the weekend when I was going through the materials that weren't highlighted in the brief, I would like to call to the court's attention. And I'll give you the citations to the amended, the revised addendum. We're looking at a situation here where the named insured, Mr. Ocampo, owned 2 vehicles and was the only listed operator on the vehicle. That's at pages 67 and 68, for both vehicles. That's at pages 67 and 68. And we're looking at a situation here where the same woman, Ms. Zapata, had actually been involved in another car accident previously, driving one of Mr. Ocampo's vehicles. So I would submit that there's certainly, and obviously, Mr. Ocampo had an $8,000 deductible on his personal injury protection coverage, so where no personal injury protection benefits would be paid if Ms. Zapata was a member of his
Can I just pause you there for a minute, because that's been troubling me. And I thought I understood what a deductible meant, and I thought that I understood that it meant that that's what the insured must pay. Am I right about that?
Respectfully, Your Honor, I don't believe so. And my understanding is that an $8,000 PIP deductible means that before any personal injury protection benefits are paid under the policy, regardless of if it's the insured or household member or whoever for that matter, then the first $8,000 need to be paid by you, whoever might.
Right, the person who holds the policy.
Or the
Not the
patient.
insurance, or the patient.
Or the patient.
Right, not the insurance company, in other words.
Correct, correct.
Okay.
Like a health insurance deductible.
And so, given that fact, and the fact that the unpaid bill was, I think, less than $2,000, am I right to think that the money that is owed under the bill, if this policy applies, the money is paid by whomever, but not by Progressive?
Correct. Which is the issue of why they're trying to find out if Ms. Zapata is a household member, because if she is, there would be no money owed to the plaintiff, because the bill is under $8,000.
What if, I don't think there's any evidence of this, or it has anything to do with this case, but let's say Ms. Zapata stole the car. A thief takes the car and gets in an accident. The insurance does apply or does not apply?
I don't believe it does. I don't believe it does, Your Honor.
All right, thank you.
How's that? Because the deductible would not apply because she's not a household member.
Oh, because it was, because the policy also states that PIP benefits aren't paid if the accident from which they arise occurs while the person seeking the benefits is committing a crime.
Okay.
And I have the if you'd like, I can cite you to the.
Progressive wins either way.
They write the policy.
Hopefully, Your Honor. The other issue I wanted to bring to the court's attention is, and you touched on it, Your Honor, the letters that were sent to Ms. Zapata were sent to the same address that is on the fire department report.
So why didn't
Cushman
they use
Street.
that? You're saying the correct address was the same on the fire department report?
I'm saying the address of 12 Cushman Street in Revere, which is where Progressive sent these letters to Ms. Zapata, was what was identified on both the fire department report and the ambulance record as well. And those are at pages 152, 138, I believe, 476 is the report. And I would note as well that there is no telephone number, there is no employer, there is no next of kin identified on any of those records. There is, however, as my sister pointed out, there is a telephone number on the bill that ultimately came from the plaintiff. And that...
So if I may rephrase this, you're saying that to the extent that it looks like Progressive did a half-hearted job trying to find her, it was actually reasonable because they were relying on what the fire department said her address was.
Correct, correct. The other issue that I noticed was, and this is at page, I believe, 172, 2 days after Progressive received a bill from ARMS, which is Mount Auburn Hospital's billing company, on May 29, 2018. 2 days later, on June 1, 2018, Progressive sent Mount Auburn Hospital the so-called EOB, or explanation of benefits. And if you look at the bottom, and I didn't, and it's my fault, I didn't highlight this in the brief, it says we're waiting for these documents. Essentially, we're not going to be making any payments. And it says, should you disagree, please contact us if you have any questions, if you want to talk about this. And it says, should you disagree with the handling of these charges, please contact us. Otherwise, we will assume that you have accepted the way we're handling the claim.
Sounds like a lawyer wrote that one.
A lawyer probably did, Your Honor. The other issue I wanted to bring to the court's attention is this text, and this is at page 483. It appears that on October 31, 2018, which is approximately 5 months after its insured hung up on them, and approximately 4 months after that explanation of benefits was sent. This is a text was sent to a telephone number, 857-251-5549. And this is 30 days before the examination of oath was requested. What that says is, or a text was sent by Progressive to its insured with that telephone number. What that text says is, I'm looking for a good phone number for Natalia, Ms. Zapata. We've been unable to contact her at this old number, 857-251-5549. I think it would be reasonable to infer, Your Honors, that Progressive, and it's not, it's not in the record.
Don't we have to draw the inferences against Progressive, given the procedural context of this case?
I think in reviewing a summary judgment motion, reasonable inferences are to be drawn in favor of the non-moving party. I agree, Your Honor. But perhaps I phrased that incorrectly.
Now, can I just go back a little from these detailed facts to the sort of big picture? PIP, as I understand it, the whole idea of the PIP benefits is it's supposed to be easy to get the PIP payments. It's no fault. That doesn't mean there aren't some issues that could be contested, but with the amounts we're talking about, you're supposed to be able to get that money out of there quickly. One could look at this case and see it as, oh, this is a case of Progressive seeking to take advantage of the fact that they appear to have either a judgment-proof set of individuals, or for whatever reason they don't want any official contact with the authorities, and they're not going to cooperate, and you have a health provider that, and again, big picture, relied on the availability of PIP benefits in treating this patient, and then Progressive gets to say, oh, no cooperation, end of story.
I agree with the first part of your statement, Your Honor, that the no-fault statutes are supposed to be simple. It hasn't turned out that way, but they are supposed to be. I disagree with the second part of your statement, Your Honor. First of all, the second part of your statement applies if PIP benefits are due. If Ms. Zapata is a household member, there are no PIP benefits that are due. And I'd like to remind the Court that there are two policy clauses at issue here. There's the examination on oath clause, and there's a cooperation clause, which specifically states that your failure to cooperate with the investigation of this matter may result in the denial of the claim. I submit that attempting to contact its insured, I believe 21 different times, by text, by telephone, by mail. Attempting to contact Ms. Zapata numerous times, and then being hung up on by your insured. And I submit that's non-cooperation. But ultimately, Your Honor touched on it earlier, I believe the record supports that even if not, and therefore, that explains some of the delay in attempting to obtain an examination on oath. But as Your Honor pointed out earlier, I believe that the law, under the laws of the Commonwealth of Massachusetts and the case law, that even if none of that had occurred, when an insurer requests an examination under oath, and there was obviously good cause for them to do that in this case, and is told, we're not coming, don't communicate further with this individual or these individuals, because that letter where the lawyer, Attorney Cravat, said that they're not going to appear applies to both the insured and Ms. Zapata. That alone, I would submit, is enough for a Progressive to deny the claim. They're obviously not going to get information as to whether or not Ms. Zapata was a household member of Mr. Ocampo. And if, in fact, that is the case, and they had reason to believe it was, then there would be no personal injury protection benefits doing it.
Okay, well, let's change up the facts a little bit. Say they made virtually no effort to contact either the policyholder or the patient. And they waited 7 months, 2 years, whatever, for bills unpaid. They have no reason to think they're not liable, but it's not until the hospital sues that they come in and say, okay, now we're going to contact you. Now we're going to do an EUO. What about the theory that timing does matter?
It's a fair, I didn't mean to cut you off, Judge.
No, go ahead.
That's a fair question. I agree with you. If they sit on their hands and do nothing, and the case law supports this, and do absolutely nothing, and then years later, without paying the bill, they say, oh, yeah, we want an examination, I would say that the PIP benefits are due. But again, that is in stark contrast to the facts of this case.
But if you're willing to acknowledge that at some point it can be so long and so inadequate in terms of contacting other parties that it matters, why is the case ripe for resolution on summary judgment?
Because I would submit, Your Honor, that two things, that when the time frame is uncontested, and the case law supports this, it's ripe for summary judgment. It's an issue of law. But in this case, we're not talking about years. For instance, my client attempted to contact by text Mr. Ocampo October 31, 2018. That's it's about 4 months after sending the explanation of benefits saying, we're waiting for this stuff. If you disagree, let us know. Otherwise, we assume you agree with the handling of the claim to the plaintiff. That's approximately 5 months after my client was hung up on by Mr. Ocampo. I would submit that if you look at the cases, and they're cited in the brief, Your Honor, where an insurance company does absolutely nothing for a substantial length of time, there are cases in there that say 11 months is reasonable.
Aren't those non-PIP cases?
No, they're PIP cases, Your Honor.
No, there may be one or two, but aren't most of those non-PIP? Because, I mean, one thing I found striking in reading the PIP statute for the first time was the fact that it expressly says that healthcare providers can sue after a month. So it really does seem to put a premium on acting quickly.
You're correct in your reading of the statute, Your Honor, but they did act, in this case, they did act quickly. First of all, which brings us to another point. I'm getting off track a little bit, but neither Ms. Zapata nor Ms. Ocampo ever reported this case. Neither of them provided an operator's report, a police report. Neither of them have done really anything in regard to this claim. In order to be, and an insured has to do all things necessary to enable an insurer to determine whether or not benefits are due. My client had to know whether Ms. Zapata was a household member of Mr. Ocampo in order to determine whether any PIP benefits are due. And they didn't waste time. Judge, this isn't something like, this isn't the case where a year and a half after the accident, they're like, oh my God, we got sued, we got to do an examination on the road. They tried to contact Mr. Ocampo, I think, 21 different times. They tried to contact Ms. Zapata numerous times, all unsuccessful. When they finally got some contact on their behalf from a lawyer, the lawyer said, we're not coming. Don't contact them any further. I'd say it's a different issue. It's a different scenario than the case His Honor presented.
Thank you very much, counsel.
Thank you.
The case is submitted.
Thank you for your time.
Our third case is 2022 P 327 Westgate versus VIBRA Hospital of Southeastern Mass LLC. If there are people from the fourth case here, I just want to warn you we're going to take a very short mid-morning break after this case.
May it please the court, my name is Ben Carroll. I represent the plaintiff appellant in this action, Sally Westgate. The central issue in this appeal is whether or not the rescue doctrine applies to the facts as pled in the plaintiff's complaint. For more than 100 years, courts have acknowledged that the rescue doctrine, holding that distress invites intervention and harm that results through that intervention is a natural and probable cause of the underlying tortious conduct. So I think it's worth noting the particular facts in this case. I think it's helpful to the analysis. On June 21st, 2020, Ms. Westgate was picking her daughter up from work at the Oaks Nursing Home in New Bedford, Massachusetts. The Oaks is a facility that sits behind and below the defendant's building, VIBRA Hospital. She picks her daughter up and they head up the access way towards the street. On her right-hand side, as she's heading up the hill, is the defendant's business. It's sort of atop a steep grass hill. While heading up the driveway, Ms. Westgate sees a woman overturned in a wheelchair. Her and her daughter stop the car. They get out to help this woman. Her daughter goes to her side, and Ms. Westgate sort of quickly assesses that this woman is likely a patient of VIBRA Hospital. She turns and runs up the hill.
Yeah, can I stop you there? We know what she thought, what do we know from this record in terms of the woman in the wheelchair's relationship to VIBRA Hospital?
So as the case is pled in the complaint, individuals from VIBRA Hospital come and collect the woman before Ms. Westgate leaves the scene from the actual access way. It's also pled that the woman was a patient of VIBRA Hospital based upon that information, and that she was discharged inappropriately. And that's kind of from the context of someone being overturned in an access way. It's derived from that information. So Ms. Westgate's daughter calls 911. Individuals from the hospital come and collect the patient, and we brought a suit in Bristol Superior Court alleging negligence, sounding really exclusively in the rescue doctrine. The defense filed a motion to dismiss, and Justice Wilkins allowed that motion on November 2nd, 2022. Massachusetts courts have consistently held that negligence which creates peril invites rescue, and should the rescuer be hurt in the process, the tortfeasor will be held liable to the injured rescuer.
Well, I want to pause you for just a second there, because there's, first of all, thank you for using the word elope in your brief, which I found very charming. You argue at page 12 of your brief basically what you just said, which is, you know, if rescue is invited, you're liable. But as I read the Levitt case, it seems to impose a foreseeability limitation on that liability. So at the end of Section 3 of Levitt, which is, I don't know, page 47, the court writes, however, not all injuries to rescuers are within the scope of foreseeable risk. Liability does not attach for injuries suffered as a result of, quote, risks that would not be anticipated to arrive from the rescue, close quotes, and that's quoting the restatement third of torts. Why does that principle not serve to, at least potentially, to limit the hospital's liability here?
Well, I think the statement is absolutely accurate. I just think the incident in this case is entirely foreseeable from the context of a rescue. And I think that what is complicated about Levitt is that it deals first with a negligence analysis and then with a rescue doctrine analysis. And I think those standards are different. And I think that the types of cases that the court and that the restatement tells us the rescue doctrine applies to are very factually similar to the circumstances here. Here we have an injured plaintiff who is immediately in the moment undertaking a voluntary assumption of risk to be involved in and facilitate the care of someone in distress, who immediately in that moment turns to seek help for that person and is on the premises of the party that we allege caused the dangerous condition to begin with.
Can we stop that for a second? Because I know she was injured, the allegation goes running back to the hospital, but I thought the actual injury took place on the adjacent property, not on hospital property.
It's the hospital's property. So there's an access way, a lawn owned by the hospital, and then the hospital's at the top of the hill, essentially. And she turns, she is running sort of immediately in time to get assistance from the people who in fact come down and collect the patient after her injury. And she falls, she's hurt, she's injured. And I think that is well within the sort of context that the case law tells us is foreseeable for rescuers. And I think that bears out in the restatement itself. Illustration 1 in section 32, I think gives us a factual paradigm that is strikingly similar to this. We have a county and a park ranger maintain hiking trails. The park ranger becomes aware that the structure to the trail is badly eroded. A hiker takes the trail collapses. Other hikers hear the distress. They go to assist the hikers who've now fallen down a ravine, and in the process of climbing down the ravine, they're injured. And the restatement tells us that is something that's a foreseeable risk associated with the original negligence of not closing the trail.
But isn't a ravine kind of inherently dangerous? And I can't recall what the allegation is in terms of what she tripped over.
A rock, I believe.
A rock, but you're not alleging that that was an inherently dangerous condition and would not have generally supported a negligence theory. It's the combination of someone who's running in rescue mode who then trips over it.
No, I don't think that Iraq is an inherently dangerous situation. I think I think the analysis really is what is a foreseeable harm from a rescue? And if a harm is foreseeable from a rescue, then I think it falls under the rescue doctrine.
Going back to your restatement example, what if the hikers that are trying to rescue the injured party don't fall into a ravine, but are just running back for help and trip over a tree root?
I think that still falls under the rescue doctrine, particularly if it's immediate in time and they're going back to seek assistance for the injured folks at the bottom of the ravine.
Sounds a lot like strict liability to me.
Well, I think that there are limits to it, and I think the restatement also tells us where those limits are. So illustration 4 gives us an example. A woman, Claudine, causes a massive car accident on a highway. Terry is driving by, stops to help. She's there for 4 or 5 hours, helping emergency crews clear the scene. She's exhausted as she leaves the scene, pulls over at a restway, and is killed by a vehicle that veers off the highway and tags her car. And that's a situation where it's just not a foreseeable risk. I think the court in Levitt is an example of where a risk isn't foreseeable, where you have something that I'd say is hallmarked by intervening negligence. You have an officer responding to a dangerous situation created by the hospital and is hit by an intervening vehicle en route. I think there's a intervening cause. I think it's much less foreseeable than what we're dealing with here. And I think this court has inclined to extend the rescue doctrine to cases that I think are, in fact, even more convoluted than this. I think Hopkins v. Medeiros itself, on its own facts, is a lot more attenuated and a lot less foreseeable than the facts in this case. And I can brief that for the court, but in that case, a couple police officers respond to an out-of-control house party. They get into a verbal altercation with Mr. Medeiros and his associate. A crowd of about 50 people form. Those officers call for backup. Officer Hopkins shows up, and while interacting with this crowd, and a new party, not Mr. Medeiros, throws a can at him. He ducks the can, and in pursuit of that individual, strains his back. In pursuit, running after that individual, strains his back, and this court found the rescue doctrine to apply to those situations because he was assisting people in need created through a dangerous situation. And I think that is even more attenuated than what we have here, where we have a woman who is engaging in sort of who's undertaking this voluntary assumption to get help for someone who's overturned. The negligence has been caused, as we allege, by the defendant and is seeking help from the very defendant themselves. I think that's within the scope of what the restatement is contemplated to be within the rescue doctrine.
Does it matter to your analysis whether the patient was discharged or eloped?
I think it would. Quite frankly, I think it would very much matter to my analysis. I think if
So let's say she had been properly discharged and then, I don't know, hit a rock with her wheelchair and turned over.
If she had been properly discharged and there's no negligence in the discharge and she hits a rock, falls over in the access way, I think the rescue doctrine likely does not apply to those facts.
Even if your client had the same altruistic reaction and tripped over the same rock on her way to get help?
I would say so, and I'd say so because I think the question is whether or not negligent conduct resulted in that situation. I think had you just come upon someone in distress on a typical road in Massachusetts, if there's no negligence in getting there, the rescue doctrine doesn't apply.
So the negligence is not in leaving a rock-strewn access way in which someone running for help could trip. The negligence is in allowing this patient who has no business being out on her own to be out on her own and possibly encounter danger.
Yes, I think the negligence is in essentially the negligence to the patient who is on the ground on the accessway. And that's sort of, in our interpretation, the way the rescue doctrine works to protect rescuers is...
Let me interrupt for one moment.
Please.
Before we even get there has to be a duty of care owed, correct?
Well, there has to be a duty of care owed to the original injured party.
Mm-hmm. And the way that I read Justice White's decision is that there was a finding of no duty of care, correct?
Well, there was a finding of no duty of care to my client, not to the injured party, and I think that's where the analysis is incorrect. And I think, quite frankly, that comes from the way the Levitt decision is written. The Levitt decision starts by addressing issues of special relationship and duty, and it has this whole analysis as to when a hospital, if ever, is liable to injured third parties for discharging patients, and then it moves on to the negligence analysis. And I think that those are two separate and distinct arguments. I think they were first dealing with a concept of liability stemming from the hospital's conduct to their client, and then the rescue doctrine. And I think that's where this sort of transition of duty gets convoluted in the record. So
The judge also limits Levitt to the rescue theory to either getting injured as a result of actually trying to rescue the actual patient, or if the patient in this instance harmed your client. And so running for help didn't fit within the analysis, according to the judge, as far as falling within the rescuer doctrine. What do you say about that?
I think the question is foreseeability. So I think and I think we've established it in the complaint, and that is that if you establish that a party was negligent in creating a dangerous situation, the question then becomes foreseeability, not to their conduct in the context of negligence, but in the context of a rescue. So what is foreseeable in creating a dangerous situation? And I think one of the things that is, I think, obviously foreseeable is that someone can get injured running to get help. I think the sort of seminal case on all this is Wagner versus International Railroad. And I think the whole point of that is that people respond emotionally to dangerous situations. And I think it is entirely foreseeable that somebody is going to run to get assistance or to the site. And as long as and I think our case law tells us this, as long as they're undertaking this sort of assumption in furtherance of rescue, I think that it's covered under the rescue doctrine.
Now, in Levitt, it was a discharge of a sedated patient. And if you negligently discharge a sedated patient, it's foreseeable that they're going to get into an accident. Let's say you're correct that they negligently discharged the woman in the wheelchair. Was it foreseeable that she would then require help, and why?
Quite frankly, Your Honor, I can't imagine how it wouldn't be foreseeable that if you discharge a patient who's going to tip over in a wheelchair, that someone's not going to stop and help them, and that the consequences of what happens when somebody stops and helps is proximately related. And I think the court in Levitt, the analysis turns on why was that police officer found to not be covered under the rescue doctrine, and I think that has to do with this concept of there's intervening negligence. And I think that's a significant distinguishing factor here in this case.
You have 19 seconds if you'd like to use it.
No, that's all I have. Thank you.
Thank you, counsel. We will hear from Ms. Burke.
Members of the panel, may it please the court. My name is Jennifer Ellis Burke, and I represent the defendant, VIBRA Hospital of Southeastern Massachusetts. The Superior Court correctly dismissed the plaintiff's single-count negligence complaint because the rescue doctrine does not apply to the facts of this case because VIBRA owed no duty to Ms. Westgate. No duty was owed because VIBRA had no special relationship with Ms. Westgate. The injury was unforeseeable as a matter of law, and the injury arose from a risk not anticipated to arise from the rescue. The alleged harm was unforeseeable where the plaintiff in this case was passing by the hospital. She saw a person she believed to be a VIBRA patient who had fallen in the street and then undertook to run up a hill to the hospital and tripped on a rock and fell. There were some questions earlier about where this was or whether it was on VIBRA's premises. That was not pled in the complaint. The complaint very clearly states that Ms. Westgate fell in the street and she tripped on a rock. I don't assume she was halfway to VIBRA from the street up the hill and then flipped back to the street. She fell in the street, according to the complaint. So this isn't a premises liability type case, and there's no evidence in the complaint as to how the patient who was tipped over in the wheelchair fell. I heard some reference from one of the justices or one of your honors about whether she fell on the rock. It's not alleged, and it's not necessary to know how the patient fell. Ms. Westgate came upon...
Which patient?
The anonymous patient, let's just say the VIBRA patient. The VIBRA patient, we don't know how she fell. It doesn't matter how she fell. She was tipped over in a wheelchair. Ms. Westgate was on a street, stopped her car with her daughter, got out of the car, this is all from the complaint, and then apparently assessed that it was a VIBRA patient and took it upon herself to run up a hill. And as she started to run, according to the complaint, she tripped over a rock, turned around, and fell face forward onto the asphalt. That's what the claim is in the complaint. And the trial court was correct in following the Levitt decision.
Before we get to that, can I just, you highlight in your brief, I think a couple of times, that she was, from all we know, the she being the woman in the wheelchair, was free to go. This was not a psychiatric hospital, nor was she otherwise confined. How is that established, given this was resolved on a 12b-6, correct?
Yes.
So what, you seem to implicitly be saying that it was the plaintiff's burden to plead this in the complaint, and I'm not sure I see that.
The question being, how do we establish that the patient in the wheelchair was free to go?
Yes.
Based on the Levitt decision, there is no, a hospital doesn't have the right to control a patient that's not a mental health patient. And this is not alleged to be a mental health facility, and it is not a mental health facility. In the Levitt case, the patient had had a colonoscopy and was sedated and was supposed to be discharged with an escort so that the patient wouldn't be a danger to himself in the street, which is what happened. He wandered into the street.
But how do we know that didn't happen here?
It doesn't matter. A hospital isn't required to tie up a patient, constrain a patient. If you've ever been to visit folks at a hospital, which most people have, you see people in a wheelchair or people on crutches.
And they make sure you get to the car with someone else driving before you get out of the wheelchair.
But, Your Honor, if you're a patient there and you're not required to stay in your room, patients go out into the hallway, they go to the cafeteria, they go outside to smoke, they go outside to sit in the sun, they go outside to visit with people. Patients aren't confined in a hospital like VIBRA, because it's not a mental health facility. You can leave at any time you want. You might be against medical advice, but you can go out.
How is that established in this record, given the procedural context?
It's not established from the record. The plaintiff has alleged that the patient eloped, I guess, inferring that she left without the right to leave, but the Levitt court makes clear that in the medical context, a patient, there's no right to control a patient for the benefit of a third party like Ms. Westgate. That's the issue. Let's assume that she left and she wasn't supposed to leave. It was against medical advice, and she left in her wheelchair and decided to roll down the sidewalk and take a stroll in her wheelchair. It doesn't matter, because Ms. Westgate is the plaintiff here, and VIBRA owed no duty to Ms. Westgate.
But I realize it's not this case, but say the facts were different, where the negligence was someone from the hospital had taken her out, but didn't set the brake, and then went back into the hospital. The wheelchair starts rolling down the hill. The plaintiff is running after her, gets hit by a car as she's trying to rescue the patient rolling down the hill. Is that a different case or not?
I think that's a different case because there's an affirmative act by VIBRA that is alleged to be negligent, failing to set the brake for a patient. That's an affirmative act. In this case, VIBRA took no affirmative action. they didn't set in motion this. The patient left the hospital in a wheelchair, which she was permitted to do.
What if she was sedated, just like in Levitt?
Well, in Levitt, the patient was sedated and actually left the hospital against the hospital's policy. One could argue that they were negligent, but we have to go back to whether or not the risk of injury to Ms. Westgate, in this case, was reasonably foreseeable. And the reason, and it would have to be that VIBRA could have anticipated from their negligent act. Let's assume VIBRA, in this case, was negligent for allowing the patient out of the hospital. We'll give them that. VIBRA still is not liable to Ms. Westgate because it could not reasonably be anticipated that a third party would come along, see the patient tipped over, take it upon herself, run up the hill, hit a rock, and turn around and fall. It's too attenuated. The example in the Hopkins, I believe it's the Hopkins case with the police officers, that was a case where the court actually did not decide that the rescue doctrine applied, but they said it was a jury question. And the reason in that case was because the incident was a melee at a house party. And the police officers called for assistance. It was reasonably foreseeable that someone walking into a melee could be injured. In this case, it's not reasonably foreseeable that if you allow a patient to leave your premises in a wheelchair who is not a mental health patient, that that patient would tip over in their wheelchair and that a passerby would run, strike a rock, turn around, and fall into the street. It's too attenuated. So it doesn't matter whether VIBRA was negligent in doing this or not, but in this case, because VIBRA owes no duty to Ms. Westgate, they have to be negligent, and it has to be foreseeable that the risk of that injury was foreseeable. Not just possible, it has to be reasonably foreseeable. And under the law and under the Levitt case, which controls this on all fours, there's no foreseeability. And the existence of a question as to whether or not something is reasonably foreseeable is a question of law. In both Levitt and this case, there was an alleged rescue of a medical facility. A medical facility defendant was involved, both hospitals, a patient who left the facility allegedly in this case without a proper discharge, and that's alleged, it's not proven. A claim that the patient should have been detained by the facility, that's in both cases, and a responding third party who was not injured by the patient and who was not injured by the same dangerous situation that the patient was in. She wasn't injured by the wheelchair, she wasn't injured trying to lift the patient, she was injured when she tripped on a rock, which means that in all relevant respects, Levitt in this case are on all fours, on point, and the plaintiff can't get around the fact that there was no duty owed.
So you see the rock in this case as being a legal parallel to the other driver in the Levitt case?
Yes, exactly. Exactly. And I know the plaintiff in their brief argued that it was more likely that there would be an accident in Ms. Westgate's case, somebody would trip and fall over a rock, than a police officer speeding through the streets to get to the scene of what's been told a fatal accident. They don't explain it in their brief. They make the statement, they make the conclusion, but they do not explain why. They also argued that because this accident happened immediately, within, I guess, minutes of the fall, we don't know that. We don't know how long the patient had been tipped over in the wheelchair. They somehow try to distinguish some temporal issue, which isn't raised in the cases.
If she's lying in the street, can't we
don't know if she's
assume it wasn't very long?
We don't know if she's lying in the street.
I thought that was pled.
I don't believe it says that she's in the street, tipped over in the wheelchair. She came upon her on the...
Returned on the asphalt in a wheelchair.
Okay. I don't know if the asphalt is the sidewalk or if the asphalt, because there's a sidewalk there, if the asphalt is the sidewalk or the road, I don't know. but there's no temporal issue to be argued. The other case that I want to highlight that the plaintiff does not address in their brief is the Poscas case, if I'm pronouncing that correctly. It's not a rescue doctrine case, but it is important on the issue of causation and reasonably foreseeable risk. In the Poscas case, a valet parking at a restaurant or an event space, they left the keys in the car and the car was stolen. The thief took off with the car, and an hour and a half later, a police officer saw the stolen vehicle and pursued the thief. The thief got out of the car and ran, and the police officer was injured chasing in the field the car thief. And the court found that it was not reasonably foreseeable for the restaurant to be liable because there were limits to the scope and the definition of reasonable foreseeability based on pragmatic judgment and policy. The police officer's injuries in that case were not the result of a reasonably foreseeable risk of harm created by the restaurant's negligence. And the court, it was the SJC, specifically said that the police officer was not hurt by the car and was not hurt while the car was being operated. And it was unforeseeable to the restaurant that if they left the keys to the car, somebody stole it, that a police officer would give chase and be injured in chasing after the person in a field. And that's, I think, very helpful to the analysis for VIBRA in this case, because of course one could foresee that if you steal a car and a police officer sees you, they're going to give pursuit. And oftentimes people will, abandon the stolen vehicle and run. The police officer ran after them. The SJC still found that that was not reasonably foreseeable risk based on the negligence of leaving the keys in the car to the to the restaurant, and the restaurant was not liable for the officer's injuries in that case. Although not a rescue doctrine, it's an important case as to what reasonably foreseeable risk of harm that results from the negligent act, which is why I said if you assume VIBRA was negligent in letting the patient elope, it's still not reasonably foreseeable from that act of negligence that a person would come along, run and trip on a rock, spin around and fall down into the street. It's the same type of analysis as in the Poscas case, which I think is on point. So that is really the issue here, because I've heard from plaintiff's counsel that it's possible that VIBRA could have thought of this, or it's possible that this would have been a risk that one could assume, but it has to be pragmatic, it has to make sense, it can't be too attenuated. The other thing I wanted to say too is that the duty to control the conduct of another for the benefit of a third party is very narrow, as the Superior Court Judge White pointed out in his order. There has to be a special relationship, and in the medical context, which is what I was stating before, it doesn't matter whether the patient was eloped negligently or was allowed to leave.
Counsel, your time is up.
Thank you.
I'm afraid we're going to have to leave it there. Thank you both very much. The case is submitted. As I mentioned, we're going to take about a 10-minute break, mid-morning break, and we will be back for Commonwealth versus MATOS.
All rise. What's the recess?
Good morning again. We are back on the record for our fourth case, originally fifth on the list, 2019 P 1448, Commonwealth versus MATOS. Attorney Binion.
To the presiding justice, and may it please the court. So the two errors initially that was where a mistrial was requested. The first one is with the testimony of Ms. Jimenez. She lets the jury know that the defendant was incarcerated when she was contacted. So let's keep this in this argument, the first argument, in context with the second argument, in the sense that there was really no great evidence that placed my client at the scene of the crime.
Can I just stop here?
Sure.
The clock is not moving. You got a freebie.
I got a freebie, thank you. There's no, I mean, this is not a closed case. I mean, the difficulty here is the victim, complainant, has a contentious relationship with the defendant. The victim doesn't really come out immediately and say that my client was the gunman. There are some problems with the government's case. So when you have a case that relies on this type of eyewitness testimony or circumstantial evidence, these types of mistakes can make a case.
Well, let me interrupt you for
Sure.
a moment, because you're looking at it in the light most favorable to your client, but the jury could find, and certainly if I evaluated this case, that's not circumstantial. It was 45 minutes delayed, but you've got the victim saying, that's who did it, 100% sure. So it's not so weak. You get the cell phone records, you have other evidence, but you have direct evidence from the person who was shot that your guy did it, right? And you're kind of morphing the facts to be in the light most favorable to your client. How is that possible? It's a jury trial, right?
It was a jury trial. And it's the jury trial that is the important part here. Because again, the defense is a claim of innocence. That's the way it was presented. And it was presented as the contentious relationship between the victim and the defendant. Essentially, the defense was that the victim was making up the story to kind of get back at my client for the contention that had been between them in the past. So when you have a jury who's supposed to actually determine the facts, this type of evidence that comes before the jury can be detrimental because it's prejudicial. The idea that somebody was incarcerated.
How surprised would the jury have been to learn that the defendant being charged with these crimes was in jail?
It depends, I guess, on how the lay juror perceives the criminal justice system.
And the lay juror also acquitted your client of some of the serious charges. So is there prejudice just in some of the charges but not in others because he was acquitted?
I've never been a fan of the split the baby idea with respect to the jury, just because, as Justice Stevens always used to remind in his decisions, is that Solomon never actually split the baby, and I think we'd have a different version or view of him today if he had. So,
But if there's prejudice,
if
one
there's
would
prejudice,
assume-
that's the problem. I mean, my client is a citizen. He deserves due process. He deserves a fair trial. He deserves an impartial jury. And the difficulty here is, and I guess in the first instance, where you have the Ms. Jimenez saying that he was incarcerated, I do get defense counsel's point a little bit in the sense that he objects. Proceedings are stopped. The jury's ushered out. He comes back, or the jury comes back. The testimony is stricken, and that's fine. But there are two problems. First of all, the jury isn't instructed, and
They weren't given a specific curative because counsel didn't want it, which...
Right, but counsel did ask for a mistrial, and if a curative instruction is given on a mistrial, then the case law says that the need for a mistrial greatly is diminished. And so that kind of dovetails into the ineffective assistance. I mean, I don't mind saying that I am trying to play all angles on this case. The judge should have done something, trial counsel should have done more, because in the end, what we're looking for is a fairly high determination that my client was the guy who pulled the trigger, not just, well, I feel comfortable that he was the one who pulled the trigger, because ultimately, beyond a reasonable doubt standard rests with you as a review on the jury.
So can I just want to sort of take you through some of those pieces of your arguing all the angles. We've obviously looked at the record. It's very clear that trial counsel was vehemently opposed to any kind of targeted corrective instruction, and he articulated reasons for that on the record. It seems that he made a strategic decision in the moment. It's sort of all or nothing, right? I'm going for a mistrial. I don't want to circle back. I don't want to emphasize it to the jury. There's already been this big fuss. We stopped. We had a sidebar. Enough already. So in terms of that, are you saying the judge abused her discretion?
No, because there's no case law that says that. But what I'm saying is that trial counsel is put in a really tough position here, and I hope you do understand that, because this court once was honest enough to say that these mistakes can sometimes be like an elephant walking through a jury's box, and I sometimes feel that the appeals court, in an effort to just, we want to make sure that the cases are affirmed, and it's a big problem to reverse cases, and I understand all that, but again, we're looking to make sure that, based on a high probability standard, beyond a reasonable doubt, that my client was the one who did it.
Can I just take a step back?
I'm not done, though, but I'm not done. Can I just ask my next follow-up question along those lines? So, because the reason I asked you about whether the judge should have overruled counsel, and maybe this will tie into Justice Sullivan's question, but maybe it won't. I can't quite figure out your ineffective assistance argument, because it's not, I mean, in a very basic way, it's sort of not listed in the headers as an issue presented. You talk about that counsel being ineffective at one point in the brief, but I can't discern the relationship between that and the issues on appeal, and I would like to understand that.
So, based on the fact that the defense counsel requested a mistrial without a curative instruction, was ineffective because the case law is very clear that without a curative instruction, it's with the curative instruction that a mistrial is less likely to be needed. That's what the case law says. And so when trial counsel says that I want a mistrial based on this mistake, but I don't want an instruction, that's problematic. That puts the defendant in a much more precarious position, especially based on this defense and the elements in this case. But given your point, I'll go to your question if you still have a question, Justice Walsh. But even if you want to dismiss the first problem, he's in jail. The second problem is a bit more problematic in the sense that it really does paint, when they play the interview, it paints my client in a much worse position as a domestic abuser, where DCF has come into play, and again, you ask the jury to ignore it once for sake of the process. I guess you have to just go along with that. But then the second time, it just becomes a bit much, where the prejudice against the defendant becomes sufficient, where the jury could then just say, well, this is just a bad person. I mean, yeah, the jury might be able to say, we have problems with the fact that, there was a contentious relationship, and maybe and we weren't there, we didn't see the victim testify, but maybe the jury thought that he wasn't that credible. But once they hear how the defendant is in jail, DCF becomes involved and there's domestic abuse, maybe that's when the jury says, well, maybe his testimony is getting a little bit more believable, because the defendant is just not a very good person. And that's the prejudice. And that's what, in my opinion, a court is supposed to protect the defendant against, and trial counsel should have been more vigilant. So the defendant can't object, he can't make these arguments, it's either got to come from the judge, or it's got to come from defense counsel. And when you have this type of mistake, and I think it's...
Can we actually drill down a little into
Sure.
this kind of mistake? Because, tell me if I'm wrong, didn't the judge initially say that the whole tape could come in? And it was after that that the Commonwealth and defendant agreed to what needed to be redacted. And the violation was some stuff came in that...
Should have been redacted, yeah.
By agreement, but not because the judge ruled it was inadmissible.
Right, well, I mean, the parties had come together through a motion limited to kind of decide this was... well, I mean, the error here is that it's prejudicial in the sense that the defendant is then put in the position of having to fight against the jury's prejudice. That didn't make sense. I'm sorry. All right. When you have these, this is just a basic prejudice argument. The types of evidence that come in on a case that's not that close, in my opinion, if the victim's lying, then, and that was the defense, then that's a problem. If you have prejudice that kind of lets the jury take their eye off of the victim's testimony.
But counsel, if the parties had not agreed as to what needed to be redacted, and the judge had stuck to the initial ruling that the whole tape could come in, then the issue would have been, did the judge err in allowing the whole tape in, correct? And you seem to be sort of skipping over that and assuming that this was a monumental problem because it was at odds with the redaction agreement. And I'm just questioning whether that's necessarily true.
Well, I mean, I think the way I look at the transcript when they discuss the error, it's not clear to me that this was supposed to come in. It looks to me like it wasn't. But even if, again, even if the parties weren't sure, when you're going to play a tape for the jury of this type of material, it's best to know what's going to be played.
There's no doubt it was a screw-up, although from this record it looks like an inadvertent screw-up.
Yeah, agreed. But again, the trouble is when this occurs. I mean, a screw-up in front of just counsel and the judge is a lot less problematic than one that's in front of a jury. And
I want to make sure that Judge Sullivan, also known as Judge Walsh, has a question.
I have a note for her.
So it's really not a question, it's more of a comment, and counsel, I'll tell you this, I've been on the appeals court for a year and a half. I've been a trial judge before that for over 13 years, and I find it offensive, your version and your belief that our job is to just affirm cases because it's so hard to reverse them. It's really not that hard, okay?
If I offended, then I apologize. My statement was more inclined to reasonable people can differ on what a beyond a reasonable doubt standard entails, and it's my belief firmly that the higher the standard is imposed, the less likely we get people who are tried and convicted on proof that is less than. Our hope isn't just to get a person for a crime, it's to get the right person, the person who did it. And while some cases are more strongly put in, or where the evidence more strong than others, this is a case where I think that these mistakes in front of a jury could affect them to the point where they're prejudiced against the defendant, and that's the problem that I see here.
I guess I want to circle back to the piece about the mistakes, because you're dealing with a record where the person who was your client's voice in the courtroom, namely his lawyer, said, I want this done in a particular way, and was offered a number of chances by the judge to ask for a curative instruction and declined every time. And against that backdrop, it's difficult for me to figure out, without a true ineffective assistance claim, how one gets to a view that the judge abused her discretion by not overruling counsel's wishes?
Well, in the end, it's the judge's courtroom, or it's the judge in the courtroom that has the ultimate say of what's going to happen. And listening to counsel can be important, but protecting the defendant's rights should always be paramount. And in this case, my client strongly feels that even though he was part of the proceedings, he feels that trial counsel should have advocated stronger in the sense that for a mistrial, a curative instruction. Because again, if you don't give the jury a curative instruction, if you don't give the jury a curative instruction, it makes I guess the way I would say it is that a curative instruction makes the need for a mistrial lessen. It's less likely that you're going to get a mistrial with a curative instruction. Here, he specifically requested that no curative instruction be given to the jury, just the striking of the statements. And my client found that problematic. I mean, if you are going to rely on the jury, at least give them from the judge an instruction where they can know the gravity of the testimony that came in inadvertently.
Counsel, thank you very much. We'll hear from the Commonwealth.
Good afternoon. May it please the court. Kristen Jang for the Commonwealth. As to the first...
It's still morning for the record.
Oh, it is. As to the defendant's first motion for a mistrial, the already in jail comment, there was clearly no abuse of discretion here for a number of reasons. Number one, the jury only heard the problematic statement once. It was also a fleeting comment that was completely unresponsive to the prosecutor's question, and she had answered differently actually at the grand jury, so the prosecutor had no idea she was going to answer this way. Number two, the trial judge promptly struck the answer from the record, even though there wasn't a specific curative instruction here as the defense counsel requested. It was still struck from the record, and the jury was instructed multiple times to disregard any evidence that was struck from the record. The jury was already aware, additionally, that the defendant was arrested and placed in custody for the charges in this case, and actually the prosecutor offered to elicit this just so that if there was any prejudice arising from this very fleeting statement, the jury could connect it to that. And finally, the jury acquitted the defendant on the armed assault with intent to murder charge, confirming that they weren't just overwhelmed by this improper propensity evidence. Oh, this guy was already in jail at some point, so he probably did this too. In a simplistic way, that's the defendant's argument, that this was so prejudicial that that's what the jury did. I think the fact that the jury returned an acquittal on the most serious charge here cuts against that. As to the second motion for a mistrial, the prosecutor accidentally playing the unredacted version of this recording, there again was no abuse of discretion in the denial of the motion for a mistrial. On this basis, the trial judge had already concluded that this evidence was admissible. There was a whole hearing held on this.
Well, if that's true, why did the Commonwealth agree to redact it?
There was probably I was trying to figure that out from the record. It seemed like the defendant was going to bring in some other evidence on this issue of these prior incidents that the Commonwealth just didn't want to get into and muddy the waters. That is my conclusion from what I read in the record. So they just decided off the record that none of this was going to come in. And this version of the recording just accidentally was played. The prosecutor immediately brought to the court's attention and tried to deal with it.
But in terms of what was behind the agreement, couldn't it have been that counsel was concerned that the judge's ruling was at the margins, and therefore to be careful when the case got on appeal, they would voluntarily agree to redact stuff that was more prejudicial and not as probative?
That absolutely could have been the reason, although on the facts of this case, I'm not sure that the judge's ruling was on the margin. This wasn't raised in my brother's brief, but at the same time, you know, this was a pretty unique case where all of these parties knew each other and had this very complicated relationship. So I think it absolutely went to the nature of the relationship between or among all these parties. And it also went to the hostile relationship between the victim and the defendant. So I think there's a lot of case law on this issue that there's a basis for the Commonwealth to offer this type of evidence that's not just for an improper propensity purpose. So sure, this may have been a strategic decision on the Commonwealth's part, knowing that they had a pretty strong case here to say, let's just try to eliminate maybe anything that might be an issue on appeal down the line, but at the same time, there could have been other reasons, like I said, because the Commonwealth would have had to probe Jimenez on maybe some of these issues, some of these other incidents of abuse that maybe they just didn't want to get into to confuse the issues. Additionally, again, the defendant declined a more specific curative instruction for strategic reasons. The judge, again, gave a forceful instruction to disregard the video played on the previous day. And again, the jury acquitted the defendant of the more serious charge here. And as to the final issue, the sufficiency of the evidence issue, there was abundant evidence in this case supporting the convictions here. The strongest evidence was really the victim's testimony. He knew the defendant, he identified him to investigators in the evening of the shooting and out of a photograph array the next day, and he testified at trial that that was the person who shot me that morning. And there was plenty of other evidence that the Commonwealth presented at trial in addition to this. So under the very familiar Latmore standard, there was sufficient evidence here. And if there are no further questions, I'm happy to rest on my brief.
Counsel, thank you very much.
Thank you.
The case is submitted. Our next and final case of the morning is 2021 P 643, John Doe number 524184 versus Sex Offender Registry Board. And I would remind the parties that the matter is impounded, so please no references to names. Counsel, I'm glad you're feeling better.
Thank you. May it please the court, Attorney Xiomara Hernandez for the plaintiff appellant John Doe. I'm here today requesting that this court vacate and remand the level 2 classification that the board gave my client because there were multiple errors committed in the decision that caused the decision to be arbitrary and capricious and an abuse of discretion. First, there was an error in the hearing examiner applying high risk factor 2. Here, the hearing examiner applied that factor because he found that my client sexually abused his niece for several years, and also, quote, that he told his wife addressed her concerns about the type of relationship they were having. However, if you see factor 2 in the regulations, factor 2 requires the offender needs to be discovered and confronted for sexual misconduct. And nonetheless
Can we drill down a little bit?
Sure.
Because the actual legal context here is interesting and a bit odd in the sense of, it is my understanding, and SORP counsel can correct me if I'm wrong, that the regulation has not actually been amended yet. So the regulation being applied is actually a draft regulation. Is that your understanding as well?
So it hasn't been, I don't think it's been amended since 2013, but again, my brother could correct me if I'm wrong, but there is case law where.
No, I understand that key parts of it were struck down.
Yes.
But in terms of the standard now being applied,
Yes.
it's still not in any final regulation. It's more, if you will, an interim policy that the SORB is applying.
That's my understanding, yes. But first of all, my client needs to be discovered and confronted regarding the sexual misconduct. Here, if you read the police report, what happened was his wife, my client told his niece that his wife talked to him one day, and that he told him if there was anything going on between them, because they were so close, I would assert that that is not a confrontation, that is not her discovering him doing anything. Possibly she suspected that there was something, going on, but in terms of her discovering, I wouldn't say that's her discovering sexual misconduct. And also, she did not confront him about sexual misconduct. So I would assert that it was error for this hearing examiner to apply that high-risk factor. And if you see, the hearing examiner only applied 2 high-risk factors, and that was one of them that they applied in order to find my client to be a moderate risk of reoffending. So I assert that without that high-risk factor applied in this case, there's question whether the hearing examiner would have made the same finding in terms of finding my client to be a level 2 sex offender. Additionally, I would say that the hearing examiner erred by giving full risk mitigating weight to factor 16, which is public place. The hearing examiner found that my client sexually assaulted his niece in his house when he lived with his mother, in her house, and also in the house that he lived with his wife. All 3 of them is a home. And I would assert that a home is not considered a public place because it's not a place where it's open to the public.
Would you address the car, please, the incident in the car?
So I would say that's a little bit different because that obviously anybody could look inside a car. There's no indication if he was driving it at night, so I don't know if it was at night where looking inside a car and being able to see what was happening. So that's why I don't address that in my brief. But the hearing examiner found that he did assault her in those 3 other places, and because of that, applied full risk, elevating risk to the weight to this increased factor. And I would say that had the hearing examiner properly found that those 3 other locations were not public spaces, that he would not have given that risk elevating factor full weight. He could have given it moderate weight or minimal weight.
What's the basis for that assertion? I mean, as I read the finding, the examiner notes the 4 things: his mother's home, the victim's home, his own home, and his car. So is it logic that makes you think if it were 1 thing rather than 4, the weight would be less, or is it something additional?
Well, I mean, the fact that he put it in there, that there was those 4 allegedly public spaces where the assaults took place, I would imagine had he found there was only 1 public place versus 4 public places, that there's a the risk elevating weight should have been less.
Counsel, are you conceding that the incident in the car would meet the definition of a public place?
I would say it could meet the definition of a public place. Again, I don't know what time of the day it happened, and I didn't include that in my brief. So I would say that those 3 other locations that the hearing examiner found that he sexually assaulted her are not public spaces.
No, certainly, it's counterintuitive to think of a home as a public place, but Sorb is arguing that if you have a sexual assault in front of a window that everyone on the street can look into, then that qualifies under the definition of a regulation. Why isn't the agency correct on that?
Well, if you read the police report, there was no indication that it actually happened in front of the window. What happened was the victim told the police that she had wished her father had looked in the window and possibly have seen them. There was no indication that the chair was in front of the window, that the assault happened in front of the window. So there's no indication of that in the record, that it actually happened in front of the window. The victim only said that she wished her father would have looked inside the window and possibly would have seen them. And also, he did make an attempt to hide his behavior. He did, make sure to stop if he heard noise. There was one incident where he was at the victim's house, and he did completely stop and made up a reason why he was there to her father. And I would also assert that, if anything, my client has a low risk of reoffending and danger to the community. As you see, my client has only been convicted of 1 index crime. That's his full criminal conviction on his record, and it was against a family member. It occurred many years ago, between 2003 and 2006, when my client was in his 20s. At the time of the classification hearing, my client was 42 years old. While he was incarcerated, he was involved in sex offender treatment. He adjusted well to incarceration, where there was no disciplinary reports issued against him. He did work, and he also was involved with welding. He will be on probation for 3 years after he's released from incarceration, which that would entail a GPS stay-away order, and for him to actually complete sex offender treatment. He does have a strong work history. He worked as a manager at Friendly's and also worked at MATOS Auto Service. And also he submitted a letter from the manager of MATOS Auto Service indicating that once my client is released from incarceration, he'll have a guaranteed job. So he will be stable in the community once he's released from incarceration. Also, my client submitted multiple letters of support from family members and friends, basically indicating that they are willing and able to support him. And lastly, I would argue that my client's information should not be on the internet because the pool of people he could possibly offend against is very small. It would involve a family member, and that pool is very small. So the public isn't really served by having his information on the internet. Any questions? If there are no further questions, I will rest on my brief.
Thank you, counsel. We'll hear from the board.
I'm going to break that glass panel. I apologize. May it please the court, I checked my phone. Good morning, Your Honors. Christopher Bover on behalf of the Sex Offender Registry Board. Justice Milkey, you talked about Factor 2 and where we are in the process with respect to Factor 2. I would note that this decision was issued prior to Judge Wilkins' declaratory judgment, so I think that's why it doesn't really necessarily come into play with this particular case, given the hearing examiner's findings, but nonetheless, even if it was in that, we would be in that situation where we have the new decision 22188, so that may have taken it away from this court. But given the facts of this particular case, under the doctrine of severability, I would suggest that the factor as it remained, Judge Wilkins struck down the first two sentences. The rest, I would suggest, receive support from the research, so that would be still in full effect, full force.
So let's talk about the research, because this is a situation in which, as you know, the regulation, or at least an important part of the regulation, was struck down because it was unsupported by the research. SORB has indicated its intent to amend its regulations to comport with the research. So doesn't that raise the question of whether or not this kind of, if you will, confrontation is the sort of thing that Dr. Hansen and his colleagues were talking about in the research that now SORB is relying on for its regulation? And it's been a while since I have read what Dr. Hansen has written in his studies, but my recollection is that it is not the kind of confrontation, that it has to be, being directly called on the behavior, not an inquiry from the wife saying, is anything going on? You're so close. So how would you respond?
So the board is in the process of updating the regulations. I have, for better or worse, am one of those individuals with the board representing the legal department within the agency going over the regulations. So I have a little bit more knowledge than maybe some of my brothers and sisters who come up before you. The board, as you well know, is comprised of a variety of experts, some from probation, some from victim witness services. Most importantly, for the promulgation of the regulatory factors, 3 psychologists. They have reviewing the documentation, the research. I can state with a fair amount of certainty that the regulation as it is right now will remain in place. And I think to your point, Justice Milkey, is that Dr. Hansen hasn't indicated one way or the other whether or not the research supports this position. So the doctors, in reviewing his research, have indicated that. And then the board is allowed, I would suggest the board does have some leeway to fill in the gaps of the research. And mind you, this is being done by board psychologists who are familiar with the research, who are familiar with Dr. Hansen. I won't get off the beaten track in terms of research regarding repetitive behavior and how that affects social deviance in the terms of psychology, but certainly a repetition does go to sexual deviance, and the board is looking at that in terms of possibility of adding a factor. I'm not saying they are, but certainly they are looking at repetition because certainly repetition is indicative of sexual deviance. Sexual deviance is indicative of risk of reoffense. I don't want to diverge too much from the facts, but in this particular case, I think you have to look at the offender, okay? His wife approached him, recognized the closeness of the relationship, and asked him, is anything going on? Okay?
So we know the wife had a concern.
I'm sorry?
We know the wife had a concern, and therefore she inquired based on her concern. Is that the sort of confrontation that the research has studied and on which the regulation got struck down, or at least the key part of the regulation, and the board is now trying to save its current approach?
I'm going to answer that in the affirmative. The answer is yes, because if you look at the police report, the way that the victim described it to the authorities is that the offender was approached by his wife, was asked if anything was going on. I'll leave it to a woman's intuition. When they're asking that question, they're not, she says, you're close to her, you're extremely close, is anything going on? I think the question is, are you having sexual relations with this individual, with this victim? And importantly, the offender talked it over with the victim and says, hey, we need to be careful. My wife is onto us, so we need to watch out. That is the type of behavior that the regulations are specifically looking at in this instance. Now, there's a question as to whether or not, and we're still hashing these things out admittedly, but there's a question as to whether or not, given that the factor sentences 2 and 3 were stricken, whether or not under those scenarios you just apply factor 2. Because again, this particular decision was issued in January of 2020 before all those decisions came down. They gave it with increased weight. But there is some discussions as to whether or not there's levels anymore in terms of even not applying factor 2. But in this particular case, given the regulation as it applied when this decision issued, I would suggest that it was done correctly based upon the facts and based upon the regulation.
Can we talk about the public space
Sure.
issue and put the car aside? A home is not easily thought of as a public space, but there is the issue of whether or not it's easy for someone to look in the window. We've heard from counsel that the only thing that references the window is, I wish my father had looked into the window, or words to that effect. Is that enough for a hearing examiner to say, oh, even looking at the house, it was a public space, because there's a suggestion in the record that somebody, perhaps standing right next to the window, could have seen something?
Two things. In the regulation under Factor 16, there's two things. No expectation of privacy, and then open to public scrutiny. So I think the car that we talked about is open to public scrutiny. I would suggest that the window, the car is both, no expectation of privacy.
Forget the car.
I know, but I just want to break it down so we understand. So the car is both, open to public scrutiny, no expectation of privacy. We go to the window, no expectation of privacy because people can see in the window. In this particular case, the offender himself was concerned that the father was going to see them, so he hurried up and fixed himself, cleaned himself up, and then lied to the father who was coming in. So the father was in close proximity to the house, to the window, enough so that the offender was concerned that they were going to get caught. No expectation of privacy. Okay, probably...
Doesn't that cut against the public space factor? Because the factor is you do something very high risk, even though a reasonable person would think you're going to get caught, and here we have behavior trying not to get caught.
Again, if you're in the house, maybe you don't have open to public scrutiny. But the facts of this case, the fact that it is in the window, is no expectation of privacy. If you're in your window, I'm sorry,
Are
Jess.
you conceding the fact that the 3 or so instances where the hearing examiner identifies the home, that was not a proper classification as a public?
Oh, no, absolutely not. Absolutely not. I'm not conceding that at all. And matter of fact, I think the regulation supports his findings because you have no expectation of privacy. Again, the offender was concerned that his mother, because he was offending in the mother's house, so the offender indicated his concern that the mother was going to catch him. No expectation of privacy. You're not really open to the scrutiny of others because you're not in a public space, you're in your home. But there's no expectation, he had no expectation of privacy because the mother was around. The incident with the wife...
Just because somebody might catch you doesn't mean you don't have an expectation of privacy. If you go into a room and you close the door, or you lock the door, even if...
Pull the shades.
Thank you.
But
I would think that those would be indications that you would have a reasonable expectation of privacy, especially in a home.
Well, we don't have a shade pulling incident in this particular factual scenario, but we have an open window.
This is not in the middle of the kitchen or dining room that these acts are occurring, right? So this
Correct.
They're making an effort. He is making an effort for quote-unquote privacy.
Somewhat of an effort, yes. Is it a good effort? I would suggest no, because again, if he has a concern, if he's in the mother's house and he has a concern that the mother is going to find them and figure what they're doing, then I would suggest his attempts to make it a closed expectation of privacy is severely lacking. With respect to the other incident, the incident with the wife, and we're dealing with variants. The incident with the mother, there's not a lot of information, but there is information that he was concerned that he was going to get caught, okay? We don't really know what particular room he was in the mother's house, so if I'm going to say the weakest argument, it would probably be, with respect to expectation of privacy, it would probably be the mother's house. With respect to the house when he was with the new apartment that he and his wife had purchased, I would suggest in that instance, the wife was walking up the stairs and almost caught them, was walking in the room, and he had to hurry up and finish up and make it look like nothing was happening. So again, he went off, but I don't know if his actions were necessarily the best in terms of getting that privacy that he was so-called looking at. And then on top of it, you do have the other 2 instances as well. So I would suggest the application of Factor 16 under those circumstances, under everything under the umbrella, would be reasonable under the circumstances.
Doesn't that argument mean that unless a sex offender offends only in his own home in which he lives alone, this public place factor could always apply?
Well, anytime you have individuals in the house, and I see plenty of police reports which indicate that the offending behavior occurred when X, Y, and Z left the house, and therefore we were the only 2 people in the house. So in those circumstances, Factor 16 wouldn't apply, because in those instances, the offender was waiting until the house was clear and then offended. In these instances, whenever you have somebody where there are other people in the house, Factor 16 can come into play in various degrees. As Justice Walsh had indicated, sure, if he's taking the victim up and everybody's having a party in the basement and he goes up to the 2nd floor bedroom, that could be looked at as an attempt to conceal his efforts.
But in many of these cases, offender waits until wife is asleep, goes down to the cousin or babysitters and offends, right? And they're not, it's not a public place, right? It's not a extra factor, extra weight on a 16, is it?
Well, I don't want to confuse open to the scrutiny of others with no reasonable expectation of privacy. So if you're in your own home, I would suggest that that's really not open to the scrutiny of others as being in a public place, which we see individuals who are committing offenses in bushes and parks and stuff like that. Certainly when you're in your own home It's not that circumstance, and I understand that, I can see that. But if you are offending in a room with, we see other instances where they're in the same bed, obviously that's a less expectation of privacy when you're offending with a third individual in the same bed, that happens. If they're in the same room or if they're right next door, if you're in the living room and the bedroom is annexed off of the living room, that's closer. Given your factional scenario, Justice, obviously that's more of an expectation of privacy. And I think the regulation is designed for the hearing examiner to consider those particular circumstances. But it would be based upon the individual facts of any given case. And we're going into hypotheticals. I think we've discussed upwards of 10 hypotheticals here, so I apologize, because it does get tricky. But in this particular instance, I think his offending behavior ran the gamut under Factor 16, so therefore, the hearing examiner's ultimate decision to apply full weight, I would suggest, is applicable.
Okay, I assume you've read 22-188.
I've read all of them too many times, Judge.
Assuming hypothetically, and this is pure hypothetical at this point, we were to conclude that the hearing officer misapplied a factor, whatever factor you want, would this have to go back to the board under 22-188, or can you credibly argue that the evidence was so overwhelming of a level 2 that we could affirm?
I'll give it the college try, Judge, if you allow me with, as I notice my buzzer's
You may
red.
answer the question.
Thank you. I'm aware of 22-188. I understand it's an uphill battle for the board. I would suggest at the tail end of that decision, there is a possibility that you could possibly distinguish this case given the applicability of the factors. In 22-188, they discussed that the hearing examiner gave, I think it was the full benefit of age, the full benefit of stability. Basically, he was applying the mitigating factors in a full effect. Here, I would suggest, and I understand the case, here I would suggest that age was applied with minimal weight. Sex offender treatment, factor 32, was applied with only moderate weight. Factors 33 and 34, which is support of family members and stability in the community, was applied with moderate weight. So the hearing examiner wasn't giving full mitigating weight to these mitigating factors. You still have the statutory high-risk factor, factor 3, which, given the crime for which he has been convicted of and was before the board, still remains a high-risk factor, factor 3. Also, I would argue that factor 7, the hearing examiner actually erred in the petitioner's favor because it wasn't actually intrafamilial, it was extrafamilial because he was the, I'm going to get this wrong, but it's in the brief, it was the stepmother's half-brother, so I suggest it's extrafamilial, and I would leave it at
Counsel,
that.
I think we're going to have to leave it there. Thank you both very much. The case is submitted.
Thank you very much, Your Honor.
This concludes our sitting. Our thanks to the court officers and the law clerks and the clerk's office for their wonderful assistance in this hearing. We are now adjourned.